Good morning, everyone. Court does call the case of Clark Road Family Limited versus Shayla Cole.
Good morning, Your Honor. Samantha Sprague, P81931, appearing on behalf of the plaintiff.
Do we?
I'm all here.
Ms. Cole?
Yes,
All right, I'll need a camera.
my camera in the front broke.
Okay, whatever. What is plaintiff's claim?
Yes, Your Honor, we're here today regarding a non-payment of rent case. I do show that there is currently due and owing to the plaintiff past rent in the amount of $4,375, as well as court costs in the amount of $239. Your Honor, my Excel spreadsheet just crashed, so if you give me just a moment, I can tell you what that balance will be.
Okay.
It would be a total due of $4,614.
Ma'am, how are you intending on getting this taken care of?
I'll be able to pay all of it by Thursday.
By Thursday, you're gonna pay everything by this Thursday upcoming?
Yes,
Okay. So I'll indicate you're gonna pay the balance by the 26th.
yes.
I'll adjourn this then to February 27th, 2026 at 1 p.m. If you have everything paid, you don't need to come down to the courthouse. Otherwise, that is an in-person court hearing. All right?
Okay, okay.
Okay. Thank you.
Thank you, Your Honor.
Thank you. Is that it for you?
I'll be back at noon.
Okay. All right. Very good.
Thank you.
Barnes and Barnes versus Chelsea. Is it Parkyla?
Ellis Friedman for the plaintiff.
And Daniel Green. Parkyla Green.
I could see Parkilla's here.
Where?
Hello.
Oh, there you are. Okay. I was actually looking for a person and not like a cereal bowl or whatever that was. Hello. All right. What is the claim, Mr. Freeman?
The total, Your Honor, including costs, is 2828.95.
Ma'am, how are you intending on getting this paid?
I've made an agreement with Barnes and Barnes that I can pay in 2 installments towards the end of the month because of how our paychecks fall. So around the 28th, I'll be able to pay half of it, and then hopefully before the end of next month. But I have made an agreement with Jessica about it.
Mr. Friedman, you know anything about that or?
No, but
Okay.
I don't, Your Honor. So I guess if we adjourn it a week, which we would normally do anyway, we'll get to the bottom
So,
of it.
ma'am, what I'm going to do is I'm going to adjourn this out a week, and hopefully that can be memorialized into maybe a conditional order dismissal or something along those lines. Okay.
A traditional order of dismissal. Can you explain what that is?
A conditional order dismissal, meaning that typically, well, the basic framework of that would be that the case would be dismissed and remain dismissed as long as you would fulfill the terms of, say, a payment agreement. All right.
Great.
If you
Thank you so
don't, then what would happen is that if you if you fail on that, then what would happen is the plaintiff would get their judgment as well as an immediate order of eviction.
Okay, great. Thank you.
Okay. But that would have to all be worked out in terms of what those terms would be. Mr. Friedman, while you may have talked to your landlord, he doesn't know anything about that. So we'll have to figure that out. So I'm going to adjourn this to February 27th, 2026 at 2 p.m. That's an in-person hearing. And likely, ma'am, you'll have to be here on that date so that we could enter, if it's a conditional order dismissal or a judgment or whatever, we can enter it. Okay?
Okay, thank you.
Thank you.
Thank you, Your Honor.
Thank you, sir. Barnes and Barnes versus Alana King.
Ellis Friedman for the plaintiff. I did see her on the panel.
Hello.
Hello, Ms. King.
Hi, good morning.
She can hear us. Can you hear us, Miss King?
Yeah.
Okay, I'm having problems hearing you. I don't know if your microphone's covered or something. Okay, can you say your name?
Elena King.
All right, we can hear you fine now. Okay, I don't know what it was, but we can hear you. All right, Mr. Friedman, what is the plaintiff's claim?
2865.00.
286500. All right, ma'am, how are you going to get that paid?
I would need a new, I guess, ledger with the full balance, but I have been in contact with Hawk, as well
Okay.
as DHS. I filed an application for a state of emergency relief.
Yes, ma'am.
This is coming after just a termination and like a string of bad luck. So I'm not as familiar with the eviction process. And so I was told to contact legal services of South Central Michigan as well. And I do have an appointment with SOS that Hawk referred me to. And
Okay,
that
that's
is
fine.
scheduled for
But-
March 7th. So it sounds like I'm eligible for assistance. It's going to take a bit of time. I know that it's getting into March here. And my concern was that it's January and February owed now. But I do hope to get assistance between that Hawk agency as well as the provisions program
Okay,
through
all right,
through DHS.
gotcha. Okay. So first thing, there's a form that came in your packet that's called a rental assistance form. You'll
Okay.
need to fill that out and file that with the court by next Wednesday.
Okay.
Okay. You said your Hawk appointment is March 7th.
Yeah, March 7th at 11 a.m.
Did they know that you were going to be in court now? Or did you
Yes.
tell them?
Yes.
Okay.
That was the soonest available appointment they had, and they said to make sure to let the court know.
Yeah, the problem's going to be, how much is your monthly rent?
11.95.
Pardon?
11.95.
So about 1,200.
Yeah.
Okay. So here's what's going to happen. And why I asked that is because if Hawk were going to give you the full amount of assistance, it's only going to be 3,000. Okay. And you're about at that figure right now. And you're going to be at, come March, if nothing's paid, you'll be at 4,000. Right.
And so I spoke with, I believe his name was Terrence. And that was a caseworker at DHS. That was I was referred to like the provisions program. And they said that they would cover up to 4,000, or whatever is the remaining balance that's not picked up by Hawk. In addition to, like, as an additional agency that can provide assistance on past due rent. I did say that, getting into March, that was my concern. So that so far is the plan. They told me to reach out to legal services to and once I made contact with someone there, that they could get the ball rolling on the application for their assistance as well. They are
So
they
which
mentioned that as
assistance
well
was
as like
that?
some DTE. I'm sorry, what was that?
Which assistance was that somebody said for up to 4,000? That's not on
It
rental
was-
assistance, is it?
It was through I've been pretty down on my luck and had some really upset I'm a survivor of domestic violence, and so the fathers of my
Gotcha.
kids have been kind of terrorizing me a little bit, and I'm not sure if that's the reason for losing my job and everything else. I'm sorry.
Okay, it's all right.
But
All right. Hey, let's do this.
CPS. They called CPS as well, and so after I spoke with the CPS supervisor, they referred me to what's called the provisions program through the Department of
it.
Health and Human
Okay.
Services. And they said
gotcha.
that they would provide additional assistance for whatever Hawk didn't cover And it would be up
Okay.
to $4,000.
Gotcha. Okay, Ms. King, do me a favor. Take a deep breath, okay? You got a lot, there's a lot going on with you and what you're worried about. Right now, don't worry so much about this. We'll walk you through this process, okay? All right? Fair enough? Okay. So I just need that form. You need to get that form down to the court by Wednesday with just that information, okay? Because that's going to get you some additional time in any event, okay? Then what I'm going to do is I'm going to adjourn this out to February 27th, that next Friday, 2026 at 2 p.m. That's an in-person hearing. If you have a reason why you might need to appear via Zoom, you can fill that form out and get that to the court and we'll deal with it. Okay? The other thing that I'm going to do is I'm going to put you into a breakout room with our court liaison officer and see if there are other resources out there that may be available to you to kind of get this, see if we can get you over the hump on this, okay?
Thank you.
All right. Amy, is she there?
Yes, Your Honor.
All right. I was going to put you into a breakout room with Miss King so you can talk with her and try to work through
you.
and see if there's other things she can work through. Okay, Miss King, do me a favor. Okay. I know you're worried. The eviction process can be kind of strange. You don't need to worry about anything right now. Okay, we'll get you through this. All right. All right. You take care.
Thank you, Your Honor.
Yes, thank you, Mr. Freeman.
I'll see you later this afternoon.
Yes, sir. Can you, okay, you got it. Peninsula Place versus Unique Homes.
Good morning, Your Honor. Rebecca Austin.
Unique Homes. Do we have her? Hello?
No, she is not.
All right, she's not here. Counsel, if you'd like to take a default, please raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God?
Do, Your Honor.
All right, go ahead.
Your Honor, so non-payment of rent, the outstanding rent, the amount of $4,916.99. Court cost of $177.72 for a total of $5,094.71. Upon information and belief, Ms. Holmes is over the age of 18, not in military service, and is not incompetent. This property was kept fit for its intended purpose and in reasonable repair.
Judgment to the plaintiff, that's by default for possession. Redemption amount in the amount requested with writ issue in 10 days. Court does call the case of the Peninsula Place versus Camille Cox.
Good morning, Your Honor. Rebecca Austin for plaintiff.
Ms. Cox? I need you to unmute and turn on your camera, please.
Okay, I'm here.
Okay, I'll need a camera. What is the claim in this case?
It's a non-payment of rent case. There's currently past due rent with cost the amount of $993.93.
$993.93.
Yes.
So, okay. I didn't know if I was double hearing or what was going on. All right. All right. Ms. Cox, how are you intending on getting that paid?
I'm going to pay the full amount next Friday.
On the 27th?
Yes.
All right. Well, you're entitled to an adjournment. I'll indicate that you're going to pay the balance by the 27th. Their time on the 27th is what? Can you get that paid early in the morning or say on Thursday?
I can pay early on Thursday.
So the reason I'm saying is because I'll adjourn this out to the 27th, 2026 at, you said 1? Yes. At 1 p.m.
Okay.
If it's paid before then they'll know, and then the matter can likely be dismissed.
Okay. I am going to have to get am I able to pay online?
No, Your Honor, when, they're in the court process, they're locked out of the online portal, so she'll have to pay with a money order or cashier's check.
And that makes absolutely no sense to me. I don't know why companies do that.
Haven't-
It's just crazy to me. I don't know why you just won't take the money. All right, ma'am, you can do it one of two ways. They won't take your money, the court will, and we'll hold it, and then they'll have to wait for their check. But I guess it's not open, so however you can do it, try to get it paid.
Okay,
Right. And you'll need to come down to, if it's not paid in full, you'll need to come down to the courthouse on that day.
okay,
All right,
yes.
okay, all right. Thank you, ma'am.
No problem.
Peninsula Place versus Taya Malcolm.
Rebecca Austin for plaintiff, Your Honor.
She's here. Malcolm,
Hello.
hello, how are you?
Good. How are you?
I'm okay. All right, what is the claim in this case?
Your Honor, there's past due rent with the amount of $2,473.21.
Ms. Malcolm, what's your plan for getting this taken care of?
I paid $820.49 yesterday. However, I do have an issue. I made a payment on January 6th at 2:00 to the residence portal before it shut down. And that was a payment of $1,000 and $1,088. However, they are saying that they didn't receive it. I did email them the receipt with Blitz, telling them that the payment did process through and everything. Shannon, I believe, is the assistant manager I've been emailing. She's seen that the payment was taken out of my account and everything, and suggested that I contacted either my bank and the rentals portal to see if they can revise to get the money back. When I went to go get my cashier's check yesterday, I did tell the bank the situation. However, they can't do anything about it. So I have to contact now the renters portal, and I'm waiting to receive the email back for them. So technically my remaining balance should be like $479 since me making the payment yesterday. And those are random charges. I have no idea. I also been emailing them since October about these charges, and I have yet to receive anything, a ledger dealing with what these extra charges are. I have no problem paying it. I just want to know what I'm paying for.
You done? No, no, it's
Yeah.
okay. That was a lot. So no, I followed it. I just didn't know when it was gonna end. Okay.
Oh,
So
sorry.
counsel, do you know anything about that January payment? I mean,
I do not, Your Honor. I will tell you that my company bought this property around that time. So, perhaps with an adjournment, I can dig into that as well. And my property manager's online as well, Holly. So, we will dig into what happened with that $1,088 payment on the 6th. That might have been right.
so as I'm understanding what's happened, so it came out of her account. The only people that it would have paid would have been either your company or your predecessor, but she would have paid her rent.
I appreciate that. Right. So it's pay, if it's paid,
Right.
we'll figure it out and give her the proper credit for it. So we can do that in next week's time.
Okay. And then she paid 800 and it was some interesting figure, but anyway.
$820.49.
What?
$800, $820.49.
Okay, that's what she paid
Okay,
yesterday.
here.
No.
Yeah.
Okay, you can hold that up. I can't see it.
Oh,
see,
sorry.
my eyes aren't
Yeah,
that
I was
good.
just-
I believe you. Do you have that on her account?
Holly, did we get that payment yesterday?
Yes, we did.
Yes, Your Honor.
So that came off of this figure
It's
that
not.
you gave me?
That 2,400 I just gave you did not include that 820, so it's reduced by that amount. I did not have that until I was unadvised before the hearing.
Okay, so I need to know if you have that 820, what is her
It would be
Give me 2473.21 minus 820. 820, and how much, what was the change on that,
49
young
cents.
lady? You said 40?
49 cents.
49.
1652.72.
That's what I,
1652.72 is actually what her balance is.
right, and then obviously reduced by another 1,088 once we get that proof, once we.
Right, and then she's just still gonna be around 600. You're thinking 400, but that's probably because without the court
Well,
costs.
yeah, it will be
Okay.
564.72. I just wanted to know what those remaining charges include. I have no problem paying it.
No,
I've just been emailing them since October.
You're killing me. I know, I heard you. All right, I'm just trying to get, I'm trying to get it to a
All my
number.
information straight.
Okay, no, we'll get there. I just have to have the number right. Okay, so now that I have the number right, we've got to get your credit, and then we can figure out what all that stuff came from. All right, fair enough. So what I'm going to do, ma'am, is I'm going to adjourn you out to February 27, 2026 at what time? 1 p.m. That's an in-person proceeding, so you'll need to come down to the courthouse. And counsel, ma'am, do you have a copy of a ledger or no?
Yes, they emailed it to me about 2 days ago.
All right. So counsel, if you guys aren't here in person, but can you make sure the court gets a copy of the ledger?
Absolutely.
So that we can try to get everything straightened out. Okay? So that this young lady doesn't have to do any more math, because I don't know why you pay 49 cents, but I'm not into that. All right. Okay. Ma'am, we will see you next week.
All right. Thank you.
Take care. Peninsula Place versus Demarius Watkins.
Rebecca Austin for plaintiff, Your Honor.
Demarius Watkins
Mr.
here.
Watkins? Okay, there you are, sir. All right. And how much is claim going on this?
$2,976.65, and that includes the court costs, Your Honor.
All right. And Mr. Watkins, how are you going to get that paid, you think, sir?
I put in the SCR and
Okay.
I got in contact with the Hawk program. I have a meeting on the 23rd of this month.
Okay. So you got a Hawk meeting on February 23rd, this Monday, I think it is. All right. And you put in SCR. Okay, so there's in your packet, there's a form called the rental assistance form. You'll need to fill that out with your tracking number from your SCR. You won't have a tracking number for Hawk, but your tracking number for your SCR, make sure that's on there, make sure it's filled out. You need to file that with the court by Wednesday.
Okay.
Okay. And then I'll adjourn your case out to February 27, 2026 at 1 p.m. Yes. At 1 p.m. That's an in-person proceeding, so you'll have to come down to the courthouse. Okay, sir?
Yes, sir. You said February, which date? I'm sorry.
27th, next Friday.
Okay, thank you.
At 1 o'clock. All right. Okay, take care. Peninsula Place versus Zaria Fisher.
Rebecca Austin for plaintiff, Your Honor.
I'm here.
Oh, where? Okay, she's the phone 766. All right. When you say you're here, your name is Zaria Fisher?
Yes.
Okay. All right. What is plaintiff's claim?
Your Honor, the total claim is $2,666.12, inclusive of court costs.
All right. Ms. Fisher, how are you intending on getting that paid?
I can pay $1,300 by Monday.
So you can pay $1,300 by Monday.
Mm-hmm.
All right. And then how would you plan on clearing up the rest of this?
And I'm just working, so I should get another check the following week.
Okay. All right. So here's what I'll do. Get the 13 paid. And then I'll adjourn your case out to the 27th, February 27th, 2026 at 1 p.m. That's an in-person proceeding. And so you'll have to come down to the courthouse and figure out, and we need to figure out how we're going to get this taken care of. Okay.
Okay, sounds good. What time was that again? I'm sorry.
That's at 1 o'clock.
1 o'clock. Okay, thank you so much.
All right. Thank you. Peninsula Place versus John Robinson.
Rebecca Austin for plaintiff, Your Honor.
Not present. Robinson, they're not present. You may proceed. Counsel.
On a request of possession only, default judgment, rents retained $1,652.82. Court cost of $177.72 for a judgment of $1,830.54. Upon information and belief, Mr. Robinson is over the age of 18, not in military service, not incompetent, and this property was kept fit for its intended purpose.
But to the plaintiff, that's by default for possession, redemption amount in the amount requested, writ to issue in 10 days. Peninsula Place versus Jonathan Jones.
Rebecca Austin for plaintiff, Your Honor.
Jonathan Jones, not present. You may proceed.
Read a request of possession only, default judgment, rents retained $1,721.53. Court cost of $177.72 for a judgment of $1,899.25. Upon information and belief, Mr. Jones is over the age of 18, not in military service, not incompetent, and this property was kept for the in reasonable repair.
Judgment to the plaintiff by default for possession, redemption amount in the amount requested, writ to issue in 10 days.
Thank you, Your Honor.
Peninsula Place versus Nafi, is it Tiwa?
Rebecca Austin for plaintiff, Your Honor.
They are not present. You may proceed.
Your Honor, I'd request a possession only, default judgment, rents retained $2,246.21. Court cost of $177.72 for a judgment of $2,423.93. Upon information and belief, the defendant is over the age of 18, not in military service. It is otherwise within the jurisdiction of this court. This property was kept fit for its intended purpose.
Judgment to the plaintiff by default for possession, redemption amount in the amount requested with a writ to issue in 10 days. Peninsula Place versus Faith Osai.
Osai, Your Honor, here.
Okay, hello.
Hi.
All right, what is the claim?
Granted, past court costs of $2,811.50.
Ma'am, how are you intending on getting that paid?
So I had been waiting on some student reimbursements, and then I just received them last week. So I have the intent of putting that down. But then I also realized my March rent is gonna come in. I only get paid twice a month because I work in education, and I had to pay a larger installment for the day I moved in. So I wasn't able to make up that payment because I was in the middle of transitioning jobs. I'm unsure if I will qualify for emergency relief because I'm technically not a permanent resident of Michigan. I'm only out here for school. So I'm not sure if they'll even make me eligible for that. But I have been, for most of the 5 years that I've been here, almost 5 years, I've been mostly in the state of Michigan. So I'm just not sure if they'll accept that application.
Okay, you're a student?
That's correct. Yes. I started at Wayne State in fall of 2021. I just transferred to Western Michigan after financial constraint again at Wayne State. So I'm online attending classes at Western.
Why don't you just stay at Wayne State?
I tried to.
I'm just asking that. I'm a bit biased. That's where my son goes. So I'm my dad graduated.
I 100% liked what I did at Wayne. I was a finance student. However, a lot of different financial situations through their financial aid office made it very difficult for me to stay. I ended up having
Gotcha.
Yeah.
Really. I gotcha. Mm-hmm. So what are you going to be when you grow up?
Actually, at Western, I switched majors. I'm now working in youth and community development. I am currently a paraprofessional at a high school within Washtenaw ISD, and I'm planning to become a family policy advocate. God willing.
No, that's a lot.
Yeah.
I wouldn't have been able to do all that. All
Yeah.
right. Okay. So, have you tried to contact Hawk at all?
I'm unfamiliar with Hawk. I got served when I was at work, so my roommate had to put the papers underneath my.
Okay. No,
I'm
that's
not
fine.
familiar
Let's
with.
do it this way. Here's what I'm going to do. I'm going to adjourn your case, first of all, to the 27th,
Okay.
2026 at 1 p.m. That's an in-person proceeding.
Okay.
Regarding you're just a resident of another state, but you're really here, correct?
Correct. Yeah. So my permanent residency is of Minnesota.
Minnesota, really?
Yeah. Born and raised.
Why Minnesota? All right.
My-
No, I'm not going to get on your back. I'm just going to say, if I had a choice, Minnesota or Michigan, I'm going to the Mitten. I don't know why you're there. Anyway, that's your business. Okay. So let me do this and let's see if there's some funding that you're eligible for.
Okay.
But I'll do that in a moment. You said you have some monies that you can put down?
Yeah, so I can put down 850 today. I get paid next.
Okay.
It might be a shorter check, but I can put down a decent amount of that, maybe like 500. My bank account has been.
Hold on a second. You can give 850 today.
Yes.
Okay. And then what were you saying?
I was saying I get paid again. It should be next Wednesday at the latest. I can put up to like 600 down on that.
Okay.
And
so next Wednesday, you're talking about the 25th.
Correct. Let me make sure. Give me 1 second.
That's this upcoming Wednesday.
Yep, that'll be correct. Because our pay periods are at the end of each month in the 15th.
All right. So that's that. And let's see. And then you're gonna be trying to work the rest of that out.
Correct.
All right.
There was a large sum of money that was taken out of my account, so I'm working through my bank with that. That was gonna add on to the additional 850 that I need to put on, but they're still working through the dispute charges.
Okay. So. All right. Okay. So let's do that. Have you not called Hawk?
I have.
Okay. Why don't you give them a call?
Okay.
You might be right on that residency thing, but there also might be certain things out there that might help you because you fall into other categories. Okay. All right. Do you have their number?
Yes, I have it on this sheet right here. Quick question about the state relief. I'm just gonna try to do the application, whatever they determine is on them. But as far as like the housing address, do I just put the address for Peninsular Place or my residency of Minnesota's address?
Whatever they ask for, but I'd probably you're really domiciled here. I mean, you have a permanent resident in Minnesota, but I know that they have helped students out before, not from as far away as Minnesota, but from Ohio. But that's only because we get more of those than I guess. What are you guys, like Gophers or something? I don't know.
Yes,
anyway.
Yuma.
Okay. Yeah, it's something like that. Whatever.
Yeah.
Never figured that one out either. But here's what we'll do. We'll do the 27th at 1.
Okay.
Call down to Hawk.
Okay.
See if you can get an appointment with them. You can fill out the SCR. Again, you might have residency requirements, but how many people are in your unit?
So I'm the only one that's in Unit A, but there's 2 other people in this 3-bedroom.
Okay. I'll just say okay. I don't know what that means.
Basically, it's a 3-bedroom, but everybody pays rent individually, so it's charged per unit. So I'm in Unit A.
It's charged per unit, but there's a common area that you all share.
Yes, living room and kitchen.
Yeah. Okay. I got that. Then those other people are whatever they are. You have your unit.
They're correct. Yes.
Okay. All right. Okay. So fill all that out. Get that done. We'll see you next week. Okay.
All right. Sounds good.
All right. I'm going to make a note. that
Okay.
she's a gopher.
Oh,
So that I'll remember. All right.
it wasn't my choice. My parents immigrated, okay?
Hey, no, that's what every kid says. It's my parents' fault. All right. Okay. You take care.
Thank you, you too.
I think that's it. That's all I have for you, counsel, for this morning.
That's it, Your Honor. Have a great weekend. Thank you.
You do the same.
Bye.
Bishop Pickering versus Mohammed Sise.
Good morning, Your Honor. David Fantera on behalf of the plaintiff.
And Mohammed Sise, he's here. I do see.
Good morning, sir.
Good morning. All right. What's plaintiff's claim in this case?
Including court costs, the balance is $2,066.88.
All right, sir, how are you intending on getting that paid?
So I would need about 2 weeks, maybe until March 6th to pay that off because I'm a student at the University of Michigan, and then I have a huge balance on my student account. I'm paying for myself, and that has been putting a strain on my income. I work on campus only.
Okay.
Yeah.
What I'm going to suggest you do is that you contact Mr. Fantera's office and see if they can work something out with you in terms of a payment time. Okay.
Okay.
I'll adjourn this out to February 27th, 2026 at 12 noon. That's
And
an
what's-
in-person, that's an in-person proceeding. So you'd have to come down to the courthouse. All
Okay.
right.
What's their contact, please? The contact of the
Attorney, it's on your paperwork. There's a phone number there for David
Okay.
Fantera.
Okay.
Okay. And that's who you'd want to contact. The other thing is you might want to contact Hawk, see if you're eligible for any other type of assistance.
Okay. Do you have that contact, or is it on the packet that I received?
The Hawk number
Yes.
is
Yes.
961 1999.
961-1999.
Okay, and that's area code 734. And then Mr. Fantera's office number is going to be on your paperwork.
Okay. Thank you, sir.
All right, thank you. We'll see you next week then.
All right. Thank you. Bye.
Sandy McFiddish versus Donovan Alexander.
Good morning, Your Honor. David Fantera on behalf of the plaintiff.
Yes, hello. How you doing?
Okay, very good. How about yourself?
Good.
Okay. And what is plaintiff's claim in this case?
Including court costs, the balance is $2,485.
Sir, how are you intending on getting that paid?
Yes, I will be having that paid off by the 4th. And I will be moving out that same month too, when my lease is up on the 31st.
Of March?
Yes.
Okay. So you're gonna pay this, you think, by the 4th, and then your
Yes.
March rent also?
Yes.
Okay. Well, I'm gonna suggest that you call the plaintiff's counsel's office, see if they can work out something regarding your move out and everything and the payment.
Okay.
And at least try to get you to that date. I'll adjourn this out to February 27th, 2026 at 12 noon. All right.
Okay.
And see if you can work it out. That proceeding that I just said is an in-person proceeding. So you'll have to come down to the courthouse. Okay, sir?
All right.
All right. Thank you.
Thank you.
Red Line Apartments versus Anthony Ned.
Good morning, Your Honor. David Fantera on behalf of the plaintiff.
Ned, they are not checked in. If you'd like to take it, do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God?
I do. Your Honor, I'm David Fantera. I'm the attorney for Red Line Apartments. As such, I'm familiar with the books and records they relate to this tenancy. The balance owing in this account is $1,803. Court costs of $173 for a total of $1,976. We'd ask for a judgment for possession with a writ after 10 days if that amount remains unpaid. Upon information and belief, defendant is not an infant, incompetent, nor in military service, and the apartment has been kept in reasonable repair and fit for the use intended during the term of the lease.
Judgment to the plaintiff by default for possession, redemption amount in the amount requested. Writ to issue in 10 days. 103 South Huron LLC versus Joshua Bertram.
Good morning, Your Honor. David Fanter on behalf of the plaintiff.
Said he's here.
He is here.
Mr. Bertram?
He's not connected to audio.
He's not.
He's been here for a while. He is not yet connected.
Can you send him a message? He's just not connected.
Yeah, I saw he sent an email. He sent a chat to the court about an hour ago, I guess.
Yeah. It just says he's connecting the audio, but.
Your Honor, I've dealt with Mr. Bertram before, and I can contact him. He has a relatively small balance of 400.
Okay. Got it. Why don't I do this? Let me just adjourn it out a week. Let you contact him and then do that. Can you let him know I'm adjourning it out to the 27th, 2026 at 12 noon?
And I will contact him, Your Honor.
All right, thank you. 103 South Huron LLC versus Jasmine Bowen.
Good morning, Your Honor. Oh, I think Mr. Bertram just sent us a text.
Yes, he did. He said he's at work. It went off my screen. He's using their laptop, but it's.
He'll try to connect through his phone.
Oh, he'll try to connect through his phone. Okay, you sent him a message, so.
I had already told him he could log out.
Oh, okay. Okay, if he comes in, we'll deal with it. Jasmine Bowen not here. Mr. Frantera, you may proceed.
In this case, there's rent owing in the amount of $1,530, court costs of $175 for a total amount owing of $1,705. We'd ask for a judgment for possession with a writ after 10 days if that amount remains unpaid. And defendant is not incompetent or in a military service, and the apartment has been kept in reasonable repair and fit for the use intended during the term of the lease.
Judgment to the plaintiff by default for possession, redemption amount in the amount requested, writ to issue in 10 days. Mrs. Haverkamp versus Jack McCaskey. That matter's dismissed on plaintiff's motion without prejudice.
You know, I just want to say on that case, I filed my dismissal and then I got an appearance from an attorney about a half an hour later, and I emailed a copy of the dismissal to them and they said, okay.
Got it.
Okay. They said they would inform Mr. Lacassi. So I had already filed the dismissal when I got that.
Okay. I don't know that. We never got an appearance. We didn't get an appearance. Okay, very good. All right, thank you.
Thank you. Have a great weekend, Your Honor.
You do the same, sir. All right, court stands in recess. Court does call the case of Clara Ganon versus Holly Ellison.
Good afternoon, Your Honor. This is Ike Start, student attorney at the University of Michigan, and I'm requesting to appear on behalf of Ms. Ellison, pursuant to Michigan Court Rule 8.120 under the supervision of Attorney David Santa Cruz.
Permission to practice is granted.
Thank you.
No?
No, she is unrepresented. She is not present. This is defendant's motion.
Yes, this is defendant's motion. But I don't have the plaintiff. So what do you want to do?
If you want to hear the motion, Your Honor, I'm willing to argue it.
I'll hear the motion, but what would you like the court to do? I don't have the other side here.
Yeah, we could go forward with the motion.
All right, go ahead.
So, Your Honor, this case was supposed to be resolved by conditional order of dismissal, which was entered by this court on November 21, 2025, and the relevant terms of that the conditional order of dismissal was that my client, Miss Ellison, was to vacate the property by the end of the year, and also facilitates funding for Miss Gannon. And then in return, Miss Gannon was supposed to return Miss Ellison's security deposit within 30 days of vacating the premises as required by law. So Miss Ellison vacated the property. That's my client vacated the property on December 5th, 2025. And that 30-day period for plaintiff to return the security deposit was ended on January 4, 2026. And we had not received the security deposit by that date. So this motion, we have two claims in this motion. First is that plaintiff violated the conditional order of dismissal. And we had not received the security deposit at the time of filing, but since we have received that security deposit after filing, and so the remedy for the breach of the conditional order was simply to get the amount of the security deposit, which we now have. That being said, we have a second claim, which is that plaintiff violated the Security Deposit Act. MCL 5546132 states that the failure of the landlord to return the tenant's security deposit within 30 days of termination of occupancy makes
Did your
her
client
liable.
supply notice? Or
yes, Your Honor. Yes.
a forwarding address?
Yes, Your Honor. She supplied her forwarding address on the day that she moved out via email. And that, I believe that's attached as an exhibit on the motion if you'd like to see that email.
Wouldn't all of the provisions of the Security Deposit Act having been waived if you are placing it in the confines of a conditional order of dismissal?
No, Your Honor, the conditional order of dismissal in no way waived the statutory obligations that would make the plaintiff.
Does it say that in the conditional order of dismissal?
Let me take a look. That's also attached as Exhibit A. Let's see. It certainly gives action to reopen the case and to reinstate the case and for the court to issue a judgment if the terms of this order were not complied with. So I would argue that the conditional order in no way waived. I would say it's pretty clear from the text that it did not waive the statutory obligations of plaintiff. So continuing on, the under MCL 554613, plaintiff is liable to my client, Ms. Ellison, for double the amount of her security deposit retained. And Ms. Ellison,
when was the security deposit returned?
It was after the date of the filing, and this was filed on January 29, 2026. So I think it was shortly thereafter. So end of January, maybe early February. But in the meantime, my client was threatened by her new landlord because she didn't have the money to pay for rent. She was relying on the security deposit to be returned. And so this caused great hardship to her, a fallout with her new landlord, and potential, more litigation. And she was very anxious about being homeless.
Was there more litigation that ensued?
No, Your Honor.
It was just her worry that she would be sued.
That's correct. And Miss Ellison contends that, she relied on the fact that Miss Gannon would comply with the law and return her security deposit. So when she moved to the new address, she told her landlord that, I'll have the money by January at the latest, January 4, and then January turned into February. And the landlord, in my understanding, was days away from initiating litigation, and my client was anxious about being homeless again, her and her son. And this was all because Miss Gannon failed to abide by the law. And Miss Ellison contends that she is entitled under the statute, and that's the statute the purpose of the statute is to protect against this exact thing, which is that a tenant would rely on the word of the landlord, but and then the landlord not following through. And I would just say one more thing is that council or myself tried to reach out to Ms. Gannon many times. When it came to our part, our obligations under the conditional order of dismissal, Ms. Gannon was very willing to communicate, always answering our calls and emails. But as soon as she got her money and my client moved out of the apartment, it was radio silence from Ms. Gannon. I emailed her, I called her, I left her voicemails with nothing in response for over a month. And that caused great hardship to my client. And so my client, Ms. Ellison, requested this court reopens the case because it was previously closed under the conditional order of dismissal and then award.
But why wouldn't I consider all of the provisions or the provisions of the Security Deposit Act were, because you'd almost have to reserve that, wouldn't you? Because everything in this conditional order of dismissal circumvents the Security Deposit Act.
No, I don't think so, Your Honor. I think
I know you don't think so, but wouldn't you have to reserve it?
Well,
I mean, give me a reason why you wouldn't have to reserve your rights under the Security Deposit Act. You're altering it. You're altering that statute in the confines of this order. For example, it's 4 days and you limited it to 3 days for the time period at which to do that. There's no provision that's laid out. And also you're saying that she's agreeing just to return the security deposit. Just return the security deposit. All of the provisions that would apply within the Security Deposit Act as to what the landlord could do have been altered.
So, Your Honor, if I may jump in for 1 second here.
No, he's doing just fine losing this by himself. Go ahead.
So I would say that normal practice is if you've got a COD that could take more than 50 whatever days it is to be paid out on, that you have to explicitly waive the law. But without an explicit waiver, it obtains. So that was our approach.
But you changed what's in the statute. It's usually a 4-day period, right, to receive forwarding address.
Well, we just did it faster, but yeah.
But you've altered the statute.
But
by the 3 days. You've also altered the rights of the landlord to do anything, because even as I read the terms of this, irrespective of whether or not there's damage, irrespective of anything, the security deposit is coming back. That's not the way the statute reads. You've altered the statute, but now you want to enforce the remedy provision that's contained in the statute.
I'm sorry, you're breaking up a little bit, but I don't read the conditional order of dismissal to really do anything other than to benefit the plaintiff. So, and the law is the law, and if we gave more grace.
No, the law is the law, and the law says that if she gives that notice, that if the landlord has damages, the landlord can do something. The landlord, with regard to that security deposit, the landlord with this conditional dismissal can do nothing but return that security deposit. You've altered the statute and the remedies provided to each party under the statute, but now want to enforce the other remedy provision within the statute. I don't think that's how it works. If what you wanted is to say that given everything we've done here, that if you don't return it within 30 days, that she'd be entitled to double the amount, then it should have been said, but it's not said.
Understood, Your Honor. I mean, my client left in a timely manner, I mean, the fact, if this might be a different case, if my client left the place a mess and, you know, and there was, you know.
But it wouldn't
itemized
matter.
damages.
But it wouldn't matter. That's what I'm getting at. It doesn't matter. She could have destroyed the whole thing. But regardless, under the provisions of this conditional order dismissal, that security deposit had to come back, which is not what the statute envisioned. You can keep shaking your head, but tell me where I'm wrong.
Well, I don't think that this conditional order dismissal would force her to return the security deposit, even if there was damages. I don't think this conditional order dismissal supersedes the law. That's my contention.
Hold on a second, counsel. How do you read that? Look at your paragraph 7. If the defendant vacates the lease premises timely under the terms of this order, plaintiff shall return the defendant's security deposit in the amount of to defendant's checking account or send it via email by forwarding to the address within 30 days of the date that it vacates. Tell me how what you're proposing could even happen.
Well, under the statute, Your Honor, I again, I don't think that the wording that we use in this conditional order supersedes the law written by the legislature. This was just an agreement to get this case settled. I don't.
Yes, you have, because you already altered it with the 3 days versus 4 days. You already altered it, making it mandatory to return it, irrespective of anything else. There's no exception here. There's nothing. There's no exception that if gas, utilities, or anything else is owed, may not have been in this case, but there's no exception in here that if something else is owed, they could take it out of the security deposit. This security deposit was coming back regardless. And the rest of the rights, this court would rule as to what would pertain under that security deposit were not retained or preserved or reserved. And so therefore, your motion to do that, I don't think is equitable and fair under the circumstances, and the court does not believe that that is the intent of the order that I signed. And so therefore, your request for relief is denied.
All right. Thank you, Your Honor.
Thank you. That's all I had on it. Try now. HP Foreclosure Solutions versus All Occupant.
Good afternoon to you and your staff, Judge Simpson. Attorney Paul Spaniello, P72366 on behalf of the plaintiff.
Any occupants?
I'm here. I'm sorry.
Right.
I'm trying to unmute sorry, Mary Cheatham.
Okay, gotcha.
Okay.
All right, this is a termination. This is a motion.
This is
I'm sorry.
Cheatham's motion to set aside a default, Judge, for what it's worth.
Did you get a copy of it, counsel?
I had to ask the court clerk, and they were gracious enough to email me a copy. Yes, I did.
All right, very good.
Thank you for asking.
Ma'am, what is your position on why I should set aside this termination?
I did not see the court document to come to the, what am I saying? Okay, so I did not receive in the mail the court date until like 3 days after the court date.
Okay, let me explain a couple things.
Okay.
There are two parts to that you would have to show this court.
Okay.
For the court to set this aside.
Okay.
All right. The first part of it being that you'd have to show good cause for your failure to appear, which I think you were going to get into. Okay. What I think is more problematic, I think, for you is you have to show this court that there's a meritorious defense to the claim of determination.
Okay. So I had entered into a lease with them. There was some problems with the payment. I think I addressed that in my motion. I have been in contact a little bit with, I believe her name is Michelle from HP. And I believe that we could possibly come to an agreement to allow me to just extend my stay a little bit so that I can get everything out of here I guess,
Who did you lease from?
HP foreclosures.
Is that right, counsel?
Your Honor, during the course of the suit, and I do have Ms. Shifter here if you'd like to take testimony, but Ms. Shifter attempted to work out a resolution with Ms. Cheatham to keep her in the property. There was an agreement that if a security deposit was tendered in first month's rent, that they would have this binding lease and that we would ultimately dismiss the case. As you'll see in Ms. Cheatham's unsworn narrative, I guess her husband or spouse absconded with the money, so nothing came of it. My client had attempted to reach out to her on multiple occasions and was largely ignored, and we proceeded. So, effectively, there is no lease, albeit, we tried to work something out with her. But if I can finish,
Sorry.
This case was filed on December 9th. The redemption, I don't have it in front of me, expired late last year. And now we're here on February 20th, Your Honor. And there's still been no monies produced. So it's our opinion that there is no lease agreement. I mean, my client would not enter into a lease without that.
But I guess, was there signed documents of a
Yes.
lease?
It's my understanding my client did sign the lease, but predicated that the effectiveness of the lease on that payment.
Okay, so I don't have a copy of the lease.
Well, it wasn't a part of this action. It was something that occurred, my understanding, during the course of this matter. When I appeared at the first hearing, I was hopeful, and I even may have put it on the record that the parties.
Well, counsel, here's the problem with that argument. Under paragraph 5F, this action was maintained because of the expiration of the redemption period, but then specifically indicates no tenancy.
Correct, and there was none at the time that the matter was filed, Judge. I'm sure Ms. Cheatham will tell you, and my client representative will tell you, that after this was filed, they were trying to work out a resolution to keep Ms. Cheatham in the.
But then we get into the other issue. So you're saying this signed document, this lease, was entered into after this case was filed?
That's my understanding, yes, Judge.
Ma'am, is that correct, Ms. Cheatham?
Yes, if they filed it on December 9th, because I don't,
When did you sign the lease?
I did, sir. I did, Your Honor.
No,
and I am
when?
prepared. When? It was in January. I don't know the exact date. Might have been like the 9th or something. I'm not quite sure. But I am prepared I have the money to pay them at least the $3,800 today.
Hold on,
Okay.
hold on, stop.
Okay.
So after this action, both parties signed a document purporting to be a lease. I don't know how there is a conditional lease, but I guess that's what counsel is saying. And Ms. Cheatham is saying that there's a lease. I don't think, counsel, you can argue that there's no lease if both parties sign this document. I don't know how that works.
Well, if I may, just for purpose of nothing else, Your Honor, making a record, there's no consideration. I mean, my client could sign a lease, and if it's predicated, it's our position, it's predicated on payment, like most leases are. And if no security deposit was tendered, no first month, effectively, there's no lease.
No, that's not how tenancy works. I mean, if she's in the premises, you're in the premises, ma'am?
I am, Your Honor.
She'd been in the premises during the whole redemption period, my
I
understanding.
have not. I was in a halfway house. I just got released on January 30th.
Well, we were here before your January 3rd. We were here on January 9th, Your Honor. It was the first hearing, I believe.
Because I'm the executor of the will, so I've been like appearing for for court hearings and things like that. But I've been pretty upfront about that. Like when I first came into contact with HP Foreclosure Solutions, that I had just been released from incarceration last July, and I've been in the halfway house since
So
then.
who's gonna send me a copy of this lease or this conditional lease or this thing that one side is purporting not to be a lease, but the other side is saying it's a lease? Because I don't even know how I begin to rule on this without a copy of it.
I don't have a copy. Ms. Cheatham or my client's representative, Ms. Shifter, I could have Ms. Shifter send me a copy and I could forward it to the court via email, or Ms. Cheatham, I guess, could. I'm sorry, Anna, I don't have a copy.
If I may, I'm sending that right now.
Okay.
Michelle Shifter.
I'm sorry, Your Honor.
Let me pass this matter.
Okay, thank you. And
then
then
it needs to be sent to my staff.
may I have the staff? Can somebody put the staff's email in the chat if they don't mind?
Can you? She is putting it in there now.
I appreciate it.
Nicholas Schultz, Lake Rental versus Ken Olson II.
Good morning, Your Honor. For the record, afternoon, Salem Saman appearing on behalf of and with Mr. Schultz sitting in my office.
All right. And you are?
Ken Olson, Your Honor.
Courtney is not here.
No, she is not.
All right. Where are we on this case?
Well, Your Honor, the last time we appeared for the pretrial, I think the only thing that Mr. Olson said was he didn't agree with the amount of rent that was owed. I have sent to the court an exhibit. I emailed it a couple of days ago that references the amount that is owed. There is December, only 25 out of the 52 was paid, so there's 2,700 left for December. Then you got January 5,200, February 5,200, which is 13,100 plus 1,275 in late fees, brings the amount that's owed to 14,375.
Late fees are how much?
$25 a day, Judge.
That's illegal. That's liquidated damages. That you can't charge $25 a day late fee. Late fees have to be reasonably calculated on a rental property. They have to be reasonably associated with what it would cost for the collection of one's rent. $25 a day is not it.
Well, that's the understanding, the agreement between the parties, Judge.
Okay, but you know, counsel, people
I do
cannot agree
understand.
to illegal, they can't agree to illegal things. And nor will the courts enforce illegal things.
Okay.
Sir, have you seen this? This exhibit.
What is, I don't, I'm sorry, I didn't.
No, it's okay.
Okay, yeah, that's the first me seeing it, but yeah, yes.
Pardon?
Yeah, I didn't, that's the first me seeing that. All it is on the paper that was sent to me to come here was the 7,900 plus late fees is what was on there.
Okay, but part of your dispute was that the amount was not correct.
Yes, that's what, during the Zoom meeting last Friday, yes.
Okay. So when you look at this document I just shown you, do you still hold that position that this is not a correct amount?
Without the late fees, yes. I mean, I know what I owe.
So you would agree that the $13,100 is owed?
If that's without late fees, yes.
Yes, that's the $2,700 for December, and then $5,200 for January and February.
Correct.
All right. Were you going to pay this amount, or what were you?
My intention is to stay in home and pay the amount owed. I just was kind of, again, when the money came out last week, what was told last week with all the late fees, I was really confused, and so my intentions are to pay the money.
When are you going to pay it? let me ask you, I'll put it to you this way. If it's 13 without the late fees, 13,100. When is your plan to pay that?
In the next few weeks,
When you say in the next few weeks, what date are you talking about? Because you're
before March 1st.
well, you understand that it's the 20th today.
I understand. It's been a rough start of the year. Money's owed to me, and
I know, I hear.
Okay. So
you're telling me, because you said the next couple weeks.
Correct.
In the next couple of weeks, I will be into March, but then you told me I pay it before March. I don't know what you're telling me. Two different things.
I understand. I'm gonna need a few weeks, at least 2 weeks. I can
But
pay.
but if you have 2 weeks, there's going to be another 5,200.
Correct.
So are you planning on paying that amount too?
I have to have a place to live. It's not just myself.
Oh, I understand that, sir.
Okay.
Answer my question.
Yes, I plan to pay to the best of my ability. I plan to pay the money owed. I've never been in a situation. I apologize. So, but I plan to pay the money owed, or I'm gonna have to vacate the premises. It's one of the two things. I understand this. It's been in a rough spot.
So I can do one or two things, counsel. Well, I don't think there's a dispute as to the 13,100. I'd grant you, I'm not enforcing the late fee provision because it's not a proper late on this account. So if it's 13,100 plus your cost, and I have your cost, I have cost in the amount of $295. So you say you can have it in 2 weeks?
Yes.
Here's what I'm going to do. We're going to find after hearing that there's no tribal issue as to at least a portion of this. I will grant a judgment to the plaintiff in the amount of $13,100 plus their cost of $295, which would be a total amount of $13,395. Specifically, I'm indicating I'm not enforcing the late fees provision. I grant this judgment today. 10 days out is going to be March 2nd. And sir, what day I'm granting the judgment today, 10 days out. March 2nd would be the 10-day period. Are you going to have this paid by March 2nd?
That is the plan, Your Honor.
With the writ to issue March 2nd or 10 days from the date of signing. That judgment then does not include March rent. You guys have to figure that out. All right. Submit a judgment to the court. I'll sign off on it.
Good judge.
Thank you. Court calls the case. Kyler Johnson versus Amadalen Bailey.
Ready, Your Honor. Dawn Van Dusen, P69647 on behalf of plaintiff.
Judge Dominic Camden, P67745, appearing on behalf of the defendant, Amanda Bailey. Judge, my client is also in the Zoom room.
Oh, there she is. All right. Where are we on this case, folks?
Your Honor, this matter it's regarding a trailer park, a mobile home in that park. My client, which is Kyler Johnson, owns the trailer in the park. Miss Bailey is his ex-girlfriend who is occupying it at this time. At this time, they did do a purchase agreement at one point, but I think I don't know where they got their purchase agreement, but Mr. Johnson would like to already told her that he was going to rescind it. He does not live there at this time, but he would like the occupancy to happen. He has a loan payment on this trailer each month that has never, it was agreed that she'd split half of it. She still hasn't made any of that. She failed to make payments October all the way to February on just that loan, which is her portion would be 500 of it. But with them not being together, it's a total of 1,000. The rent there on the lot,
Because they're not together, her payment went up.
well, they agreed they would split it at one point, but she hasn't made any of it. So we're not even asking for a judgment in this matter. We just want, as in a money judgment, we'd just like Miss Bailey to move out of the home, out of the trailer. She's changed the utilities into his name, into her own name. She has, so he cannot even get access to make sure payments are made. So she's actually only made payments starting in January for the utilities. So we're asking at this time that eviction of a 10-day order be granted to order her out of the premises.
Mr. Hamden.
Judge, the parties are subject to a purchase agreement. I don't believe you can just unilaterally rescind an agreement. I don't believe the purchase agreement provides for that. And my client is still wishing and desiring to go forward with that purchase. Second of all, my client is on the written lease agreement with the park. And so she has the right to occupy this space as the landlord to the property. So this is probably better characterized, Judge, as some form of a replevin case, as opposed to an eviction in order to retain his property back. It's not properly characterized as an eviction. It's probably better characterized as some form of a replevin.
Well, but I don't. Is the purchase agreement still in effect?
It did not have a termination date, Judge.
Your Honor, it also says the initial payment is non-refundable. It looks like she received this piece of purchase agreement, a copy of it, and that she filled it out, and it was part of the parks where if they were going to sell you one of their trailers. I mean, there was no down payment. There's no initial payment that it discusses is non-refundable unless the applicants are denied their credit and background check. Your Honor, this is not a normal purchase agreement, and it has no closing date, no nothing on it. My client has rescinded 2 days after he signed it and said he does not want to sell it to her.
And again, my comment on that, Your Honor, would be that my client was prepared to close on it, had coordinated with a lender in order to do so, and he refused to go forward with the closing, and there is no provision in there which allows him to unilaterally rescind it. I think it's also worth noting, Judge, that the parties, and I'm sure Your Honor has put 1 and 2 together, at one point in time dated each other. And one of them was required to leave the premises because of a police report. And so what this appears to be is
oh dear God. Is that true?
Your Honor,
hold on a second. No, I just need a very clear answer because this court has a very clear policy on that. And I'm just going to say, because usually it's the male that's doing this. Is there a domestic violence complaint that was made?
Yes, Your Honor, it was made on October 23rd.
And he was then required to leave the premises?
Correct.
I am not.
And Your Honor, there's no charges pending against my client. In fact, the charges were dismissed by Miss Bailey 2 days later after she made the complaint.
Okay. How long were they living together?
That would be something that my client would have to answer, Your Honor.
Judge,
Miss Bailey? How
We were
long?
living together 1 year.
Okay. All right.
Your Honor, I wanted to add something. I just wanted to say that the reason why of wanting to go back on the purchase agreement was because initially I had signed the purchase agreement, and the next day she was trying to falsely accuse me of, and call the cops on me for stuff that wasn't done, and just falsely accuse me. So that was
So
why
you
I
got
wanted to
mad
go.
and said, I'm rescinding the purchase agreement, blah, 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 blah. I hear it all. All right. So what do you guys want me to do? I am not issuing a judgment, not today. And I'm assuming, Mr. Hampton, you want to file a written answer to this.
I do, Your Honor, and I think it would be helpful if the court actually saw the purchase agreement, as well as the lease
Well,
agreement.
somebody attach it, because if the
I'll-
purchase agreement's there, but there's also another signed document between the parties, correct?
There's a purchase agreement that was signed between the parties, Judge. The other agreement was signed with the park landlord, to which my client is a tenant, as well as Mr. Johnson. They are both tenants from the park landlord standpoint. I will attach both of those to my written answer.
So yeah, that was going to be my next question. So under what theory is the plaintiff terminating the tenancy?
Eviction, he owns the mobile home that she is living in at this time. He owns the mobile home. He actually has a mobile home mortgage that he has to pay every month. On top of that, then they rent the property the mobile home is on. So the only thing they have a lease for is the property that the mobile home is on with that park. So all he has to do, and which he has already started doing, and is he has to go in and get her off the lease, which means he just has to do
If I went to a family court and deal with a divorce, that's not really a divorce, I would have done that. I don't know why I'm even dealing with this mess.
Because it's an eviction, Your Honor.
I don't know that it's a proper eviction, because I've got a purchase agreement for property that one is saying I got mad and I just rescinded it after I signed it. The other party is saying, well, I'm sitting in here and he's gonna, I mean,
Yeah, the terms of this purchase agreement haven't even been fulfilled by her. She's already, at the beginning, she was supposed to give him initial payment, and that has never been done. So the terms of this purchase agreement are
yeah,
so
but your
vague.
client just said that's not the reason why he wants to rescind it. He wants to rescind it because he got mad because she was saying things. He just
Your
said
Honor,
that to me.
Yeah, she has not even made in good faith an attempt to go try to finance this trailer.
My client had it financed, Your Honor, and was prepared to close. And I'm looking at the purchase agreement, and I could be wrong, and I
Here's the
don't
thing.
want to be held out.
You
Judge.
can keep talking.
There's
I don't
nothing
really
in
care.
I was gonna say,
I don't really care, because if there's a purchase agreement, you're saying that she's not doing whatever. And okay, fine. But your client just told me that's not the reason why he rescinded. I mean, counsel, I'm just going to let you know, because if there was a domestic violence accusation, this court has been very consistent with its files. If there with a police report filed, whether it's carried through or not, the court is going to be very reluctant to evict someone who may have been a victim of domestic violence.
I
And
understand,
I'm getting the sense that that's the reason why the purchase agreement didn't go forth. That's the reason why everything is now being sort of couched as this eviction and this is my property.
But Your Honor, this could also be a reason how she gets him out of the home. She knows if she calls the police, makes false allegations, that he has to leave the premises. There's a reason it got dismissed 2 days later.
Well, you said she did it.
Well, she did. She went and, she made the allegations to get him out of the house. When he said, well, I'm not going to sell you this property anymore, then she says, I'm going to go dismiss the charges.
Mr. Hamden, how long do you need to answer?
Monday, Judge?
Pardon?
Monday. I'll get it going over the weekend. I actually had intended to get it going earlier this week, but my judicial secretary called in sick and everything was fine. I had no problems whatsoever, but I didn't get it done. So
All right. Defendant to file an answer by, well, I'm going to give you a week to get an answer in. You're to file an answer by February 27th, 2026. And then I'll set this for an additional hearing. The way this is out, there's no reason for me to set this on a Friday. Give me a Tuesday that I can hear this.
The first Tuesday would be March 3rd.
March 3rd. I'll set this for, I'll call it a settlement conference. I don't know that that's going to happen. March 3rd, 2026 at 9 a.m. All parties are required to be present in person, including attorneys.
Thank you, Your Honor.
Thank you.
thank you, Judge.
Court calls the case of Clark Road Family Limited versus Severin Claiborne.
Good afternoon, Your Honor. Attorney Samantha Sprague, 81931, appearing on behalf of the plaintiff.
I'm present, sir. Your Honor.
Pardon?
Oh, this is Severin. My phone was muted. I was trying to unmute it. I said I'm present, Your Honor.
Oh, she is present. Yeah. Okay. All right. Where are we on this case?
Yes, Your Honor. This is a non-payment. It's a subsequent hearing. We do show that currently there is past due rent in the amount of $5,019 and court cost the amount of $239.72 for a total due owing of $5,258.72.
Okay.
How'd that happen?
I'm sorry?
When is her rent due, counsel?
Yes,
First of the month?
The first of the month, Your Honor. It looks like the last payment was received in November 5th of 2025 in the amount of $1,623. No rent has been received for December, January, or February.
I wrote something down very wrong, and I have to go back and look. But when we were here on the 13th, I think I was given a balance of $1,877.92.
Give me just a moment. I do believe there was a failure to recertify. That may have. Let me check that real quick.
Oh, Your Honor. I had went to recertify. I think. Did you ever receive the note, the letter that I had wrote out for you?
Who?
With the dates and everything.
The note you sent me?
Yes. When I had came to turn in the last time when you had told me the paperwork like with Hawk and everything on it, and in the packet I had to fill out the paperwork and turn it into the court. I had also left a documentation of dates, and issues and stuff that I had been having, and I had submitted that in November. I had never failed to recertify anything. I went to recertify in November, and I had wrote. They just called me probably like the day before court, or it was in that week frame. But they called me and told me that my recertification was never completed, which it was completed. And I told the lady of corporate, I said I absolutely did go and complete that.
Are you talking about, ma'am, when you say a note, are you talking about an email that was sent?
No, it was like the print off. Like I printed off along with the paperwork that I had to submit. It was something in the packet that you told me to make sure that I submitted. It was like 2 pages.
Okay. All right.
And
fine. Then. So.
Your Honor, if I may.
Yes.
I don't believe my client is on the hearing. If it's possible to get this rescheduled for 2 weeks out for an in-person, we'll confirm with my client regarding the amount and also speak with the defendant
Okay,
regarding.
but, well, and let me just say this,
Wow.
counsel. My staff checked to make sure I didn't write something down wrong, when, a week ago. And the 1877.92 is the number you gave us
Correct, Your Honor.
as owing.
Was provided to us with the initial.
Right.
We do sometimes see that individuals lose their voucher, and I don't have any notes indicating that's what happened here. Which is why we're respectfully requesting a 2-week adjournment so we can confirm with my client that balance amount.
Ma'am, do you have any objection to the adjournment in this matter?
Well, Your Honor, can I just say two things really fast? As far as me never recertifying, that is absolutely not true.
Ma'am,
I had
ma'am,
went to recertify in November.
Ma'am,
Yes.
I can't
Yes.
understand that I can't do anything about that because I don't know if this balance comes from that or not.
Okay, well, well, the last thing I will say, and I'll leave it at this, is they called me saying that they lost my lease at one point and asked me to come back and re-sign. And then, like I said, corporate just called me like a few days before court and told me that I had never finished my recertification, which my mama taught me to document everything when I do it and put it in writing.
Okay.
So the
I
day
hate
that I
when I'm
document it, I
speaking
still
French
have.
because apparently you're not understanding me. I can't do anything about the recertification issue until I can see what the balance is.
Okay.
I'll adjourn this matter. Well, I'm gonna set it for, I understand what you're indicating, counsel. Why don't I set it for Friday? I just gotta get a solid number, and then if I have to move it to a Tuesday, I'll do that.
Your Honor, I will be out of the office on the 27th. So that's fine as long as it's not next week.
Right, I was gonna go to March 6th.
Yes, that's perfect.
So pardon?
I said thank you.
All right. I'll adjourn this matter March 6th, 2026 at what time?
2 p.m.
At 2 p.m. All right. Thank you.
Thanks.
Court calls the case of Clark Road Family Limited versus Monica Drummer.
Attorney Samantha Sprague, P81931, appearing on behalf of the plaintiff in this matter.
Oh, she came down in person to yell at me. Hang on. We're waiting for her to get it to the podium. Wow. Did you see it? She tried to throw something. You saw that? You gonna take her down? You got it? She's good? All right. Your name.
What you want from me?
Your name. Okay. All right. What is plaintiff's claim?
Yes, Your Honor, this is a non-payment of rent. We do show that currently there is a past due rental rate in the amount of $1,462 with court costs of $219.72 for a total due and owing of $1,681.72. We would note for the record that I was notified that the Section 8 housing voucher program has been terminated for this tenant.
Has been terminated?
Has been terminated. I'm waiting to confirm with my client whether it is terminated effective as of 3/1 or if they are retroactively applying that termination.
You know anything about that?
I just learned about it same time the complex did.
I'm sorry?
I just learned about it at the same time the complex did. I never received anything in the mail.
Say why it was being terminated?
My daughter and ex-husband caused my voucher to be terminated.
Pardon?
My daughter and ex-husband caused my voucher to be terminated.
Your daughters and your ex-husband or their ex-husband?
No, my ex-husband and my daughter.
Your ex-husband and your daughter?
Or our daughter, should I say.
Okay, cause your...
I just went through a messy divorce, so they attacked my Section 8.
They what?
He went after my Section 8.
Okay. Are you going to get an attorney to represent you on this?
I called, I talked to Amy last week and we talked to, was it HAP?
Yeah.
So they're working on, she's supposed to call me yesterday. I haven't heard from her.
All right.
I submitted the documents that she wanted and she's supposed to call me back. I haven't heard from her. She's supposed to call me Thursday morning at 10 o'clock and I haven't heard from her.
Okay, but at this point, we don't know when that termination is going to be effective in any event.
Well, from what they told me, It was terminated June 30th, from what I was told.
June 30th.
That's what they told me. And I never knew about it. And the leasing office,
But
they never told me.
Stop. But there's been payments since then.
See that? I don't know.
So I don't know how that happened.
I don't know. They told me they haven't received the payment. So I don't know, Your Honor. I'm being told one
March,
thing.
I'm going to adjourn it out 2 weeks, March 6th, 2026 at 2 p.m. Let's figure out that it'll give you time to get an attorney if you want somebody to represent you or deal with that with regard to your voucher.
Okay.
All right?
All right.
Thank you.
Welcome.
Thank you, Your Honor. Have a good.
Okay, take care.
We did have
Westbrook
this-
Apart-
My apologies. I was just gonna let you know, we did submit a dismissal regarding the Bonita Allen. I just wanted to make sure that was off your docket.
That is correct.
It's off. It's
Thank you,
off.
Madam Clerk.
Good.
Thank you, Judge.
All right, take care. Westbrook Apartments versus Marilyn McCarthy.
Good afternoon, Your Honor. Mark Swassenger appearing on behalf of plaintiff.
Is not checked in. Writ signed, issued. She filed a motion on this, right?
That's correct, Judge. So procedure, there's a default. The writ was issued after a writ hearing. Ms. McCarthy failed to appear at that. Then she filed a motion either to set aside or stay the writ. One of the two. We were here last week. There was some discussion or concern regarding payments from the Ann Arbor Housing Commission and today's date. So, I mean, I can give you an update as to what's going on, and then Your Honor can, I think I understand what's going to happen. But I guess I don't know because I don't wear the black robe.
You said, I'm sorry, you broke up on that last part.
Oh, I said, I said, I think I might understand what's going to happen here, but I don't wear the black robe. So Your Honor, tell me what will happen. But here's where we're at, Judge.
Well, yeah, if she's not here, I know there was supposed to be some checking with that. I'm going to deny her motion and the writ can go forth.
Fair enough then, Judge.
All right. Then the defendant failing to appear, motion denied, writ may be executed.
You need me
I think I've already said it.
Do you need me to submit an order to that effect, Your Honor? Or
no, that's fine. I think I had already issued the writ.
That is correct, Judge. We do have an entered writ.
So now I'm permitting it to be executed.
All right.
All right.
Very, so much.
All right. Thank you.
Have a good weekend, Your Honor.
You do the same.
Thank you.
Syed Hussein versus Obey Al Ahmad.
Good afternoon, Your Honor.
There is no counsel, Your Honor. That is the defendant. I do not have the plaintiff checked in.
Well, your name?
Saeed Hussein.
And your name, sir, is
Obey.
You are Obey
El Ahmad, yes, sir.
Last time I was here, the claim, well, at the end of January. How much are you claiming is owed at this point, sir?
At this point, it's $5,590, which includes January rent, February, and also he stopped paying the water bill since last year. May of last year, he stopped paying the water bill. That's under my name, so it accumulated to $1,790.
Say how much?
$1,790.
So what's the total amount you're claiming is owed?
$5,590.
And part of that is the $1,700 water bill.
Yeah, that's included. Everything's included.
Sir, what do you have to say to that?
Yeah, so I'm in agreement with him on the 3,800 portion. The 1,700 I do owe, but it's stated in the lease that that's not a part of the rent itself. That's kind of a separate bill that comes in that I got to take care of, which I will take care of course. I'm not denying that claim at all. As for the 3,800, I communicated with Mr. Hussein and had asked him that, hey, I can make a weekly payment with you to take care of this full balance up until my tax return arrives, which was supposed to be the 6th of February. That was under a past PATH Act hold, which I was unaware of, as this is the first time I'm going through it, but they have released that hold and my tax return should be arriving within the next week or so, where I can take care of that balance. But as for the utilities, that's a separate bill that comes in that's not included in the rent as well as in the
Usually
lease.
utilities are included as part of your rent once they become past due. But
correct.
Is there
And
a written lease?
Yes, I included it with my motion. Included a lease in the first page. It says all utilities should be paid by the tenant.
which I'm not disputing at all. That's where maybe the miscommunication comes in. I'm responsible for that $1,790 or so change that he's claiming. It's just that that's not connected to the lease, and it also
So let me
states.
ask you this, sir.
Yes, sir.
When are you gonna have all of this paid? It sounds to me like you're not really disputing it. When are you gonna pay it?
Yeah, so like I said, I was supposed to get the tax return by now and we wouldn't even be standing here, but it says by Monday is when I'm supposed to get that tax return because of the hold that was on that refund, the PATH Act hold, which I was unaware of as well. So that's why there's such a delay with everything. But I expect it within the next week. I should get it in my account. I should be able to pay him in full, which I communicated with Mr. Hussein that.
So the amount that you're claiming is owed is $5,500 or $5,590?
Yes, Your Honor.
Which one?
$5,590, Your Honor.
90?
90. That's with, without.
That didn't include your cost?
I'm sorry.
Did you include your court cost in that?
I haven't, Your Honor.
If I may say something, Your Honor, I know in the lease it says at the bottom if there's any unpaid rent, he will deduct it from the security deposit.
I'm sorry?
It says at the bottom of the lease that if there's any unpaid utilities, that he would deduct it from the security deposit. He has that in the lease.
Right, but he can't do that until you move out.
I mean, I'm willing to pay, everything. I'm trying to take care of the rent so I can get back on track with that. And then I can figure out a payment plan with the water bill department themselves by giving them a call and, figuring out paying them back. I didn't want it lumped up with the rent. That way I'm kind of having to take care of two problems at once. I just wanted to take care of his rent and then call the water department myself and maybe ask them for a payment plan or something of that nature to take care of the water bill.
Well, how come you didn't do that already?
I was waiting for this court date, Your Honor. I've been trying to communicate with Mr. Hussein this entire time, and I've asked him I can make payments, and he's kind of just ignored me.
Court finds no tribal issue. The court is going to grant a judgment to the plaintiff for possession. I'm going to include the water bill. The court, as they look at it, the water bill is due under the terms and provisions of the lease. And so the total judgment amount will be $56.91.24. I'm sorry. Yes, 24. 56.91.24. I will, sir, do this for you. The writ would normally issue on the 2nd, where you can evict him. I'm going to give him till that Friday to do that, till the March 6th. So I'll extend the time for you to get the payment in, but you'll have to pay it by March 6th. You understand that, sir?
Yes, Your Honor. Could you please repeat that a number for me, please?
$5,691.24.
Okay. Before that Friday, that first Friday of March.
Right. That doesn't include your March payment. That's just what's due right now. All right. Thank you.
Thank you.
Thank you.
You'll have to submit a judgment, sir. You'll have to go up to the counter, ask them for a judgment, and you have to submit it to the court.
Okay.
Okay. Thank you. Pierce Lake Village Association versus tenant. Don't know what that means. Well, tenant, and then there's James Heaton Trust and Ellen Green Living Trust. Oh boy. Go ahead, state your names, please.
Good afternoon, Your Honor. Lydia Camoro appearing on behalf of Pierce Lake Village, P85454.
Good afternoon, Your Honor. Travis Gagne, appearing on behalf of defendants. I am co-counsel, though my formal appearance has not appeared, with my co-counsel Angela Jackson.
Got it. Okay. And this is a termination. Dare I ask, where are we on this?
So my understanding is the initial hearing was on February 13th. My colleague appeared at that. None of the defendants had appeared. Last week we were scheduled to reappear, and Angela and I stipulated to adjourn it 1 week. So this should be the first hearing on the eviction matter.
Well, there was an initial hearing on the 6th. And then the 13th. I'm not sure what happened. I didn't have a docket the 13th, did I? No, I did have a docket the 13th, and you stipulated to adjourn it.
Oh, yes.
And that's why we're here today. You're a week off, but I got you. All right. So now where are we on this whole case?
Well, I wasn't aware. Are you representing all defendants now?
I'm going to be representing all defendants, although I will note for the record that Ellen Green Living Trust is not an owner of the property, so an improper defendant in this case. James E. Heaton Trust owns the property, and then there is a tenant living at the property. So at least as to Ellen Green Living Trust, that should not be a defendant in the case.
Your Honor, I believe on the deed, and let me see which exhibit this would be. Yes, if we look at exhibit 1 attached to our complaint, it names it names that it was conveyed and warranted to Ellen Green Trust, which is why we named her.
Whose interest was conveyed?
James E. Heaton Trust was conveyed to the Green Trust and James E. Heaton Trust. So our understanding based on this deed, Your Honor, was that both of the trusts own the property and therefore would be responsible for the money judgment that we are requesting.
My understanding is that, again, this is a tenancy deed. My understanding is that there is not a financial interest from the other trust. I'm happy to file a formal motion, though, as it comes to striking a defendant and attach proofs and evidence in regards to that.
All right. So I'm not, I guess as we sit here right now, I'm not sure that I have the party straight. Because you're claiming that the Green Living Trust is a proper party, you're saying that it's not.
I am saying that it's not a proper party, but I'm appearing on behalf of all of the named defendants at the moment. So
okay,
I am here and everyone is represented.
All right, but we've got to figure that all out.
Yes.
All right, how would you guys like to proceed forward?
I mean, you've seen the complaint here to recovery. My understanding is that there are two complaints that they have. Again, plaintiff here is the HOA. They are not actually the property owner. They are moving for an eviction, but not necessarily possession of the property, since they are not entitled to possession. The owner here, as it goes to damages, the James E. Heaton Trust, they are trying to evict the tenant. The items complained about are...
Have they requested that the trust evict the tenant?
Your Honor, under the Michigan Condominium Act, specifically MCL 559.212 Section 4, the condominium association has a right to move for eviction if the tenant is.
It may surprise you, I know the law. I asked a question as to whether or not they had asked the owner of the premises to evict the tenant.
Not directly, Your Honor, but they received the bylaw violation letter, which gives them 15 days to cure, and that has not been.
Okay. Your Honor,
So that's a no?
I'm going to say that's a no, Your Honor. They have not requested eviction. They have stated that there's a damage to the outside door fixed at owner's cost, and they have said that there are multiple noise violations and that they should cure the noise violations. Our position is that the noise violations have been cured. They have not produced any police report that since this time of saying that things should be cured, or their notice to quit, that there have been any additional police reports, and I will note that in the police reports, the police did not actually find any evidence of there being noise violations. They noted that they didn't hear any noise, and there's a declination to prosecute that's in the file that was filed by plaintiff in this case. There's been no, I mean, the complaint frames it as saying there hasn't been a cure because the tenant is still there. There's been no request to evict the tenant. I don't think there's a basis to evict the tenant. And so our position here is that there is not costs owed. There's not a request for a common element to be fixed or anything like that. And there's no, there's no further noise violations. So I think it should be dismissed.
Your Honor, we respectfully disagree. Under the bylaws, there's a specific requirement that there's no noisy activity. And there have been numerous calls to the police department evidencing, and we will bring witnesses at the subsequent hearing, but I wasn't aware that that counsel was representing all of the defendants. In fact, in my communications with Ms. Jackson last Friday, she advised that she did not know whether she would be representing all of the defendants or not, and therefore hadn't contacted me since, nor filed an appearance on behalf of all defendants as of today's date. But we will bring witnesses to testify regarding the noise at the subsequent hearing.
And Your Honor, just to
But is that going to be the basis for the termination?
Yes, Your Honor, and that is appropriate under the condominium documents.
But has the noise, these people are going to come forth, say my neighbors are noisy. I'm hearing this noise. Has that been cured?
No, Your Honor, and in fact, it's loud screaming and pounding on the walls. It's not just, some loud music or something of that nature. And this happens throughout the day. And this is a problem that has disrupted the neighboring homes.
This is why normally in these cases, counsel, I realize what the condominium act indicates, that usually the owner of the premises is contacted, asked to correct the tenant's behavior and or evict. When they refuse or don't do so, then the homeowners association acts.
Your Honor, they received the same bylaw violation letter, which provides them the opportunity
All
to
right,
cure.
I know you told me this.
Correct.
I do hear, I understand, but okay. I guess we're just gonna go down this road. All right, yeah, go ahead.
To contextualize, the tenant who is currently there is a relative of the owner, the trustee of the trust. There's the word that I'm looking for. I don't think that it is necessarily contested that the tenant has dealt with some mental health issues of which the family is trying to provide him services for. To the extent that they are sending cure letters to the owner to correct noise violations. Again, the curage here is any damage that has been reported, which is again just some exterior damage to the door will fix at owner's cost. Noise violations are being addressed for the procurement of treatment. I think what's being asked here is an HOA to throw out somebody with a known mental health issue onto the street because they don't like their neighbor. And frankly, we're ready to contest that.
I don't think I have an answer from you guys yet, right? How long?
No, if you, frankly, I could get it by the end of today, but if you would give me till Monday, I'm happy to file the formal.
Defendants to file answer. I'm gonna make it by February 27th, 2026. And then you get that, I guess I'll reset this to the 6th. We have, correct?
You have the 6th, yeah.
Then I'll adjourn this out pending that answer to March 6th, 2026 at 2 p.m.
You're in person with you, Your Honor, correct?
Pardon?
You're in person with you?
Yes. So everybody can see how my joyous day goes. Yes, all right, thank
Your
you.
Honor.
Thank you, Your Honor.
Edward Roberts versus Veronica Roberts. Hello, sir.
Sir,
Is Veronica Roberts here?
no, she's not.
All right. This is termination.
Yes, sir.
All right. Raise your right hand. Other right hand there.
Other right hand.
Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right. And your name is Robert Edward Roberts?
Edward Roberts, yes, sir.
Yes. And you're the owner of the premises?
Yes, sir.
On Platt Road, is that correct?
Yes, sir.
All right. And that Veronica is a tenant in some way of those premises?
Yes, sir.
All right. And who is Veronica vis-a-vis you?
Granddaughter.
Your granddaughter. Okay, so your granddaughter was living there and you wish her to vacate the premises, is that correct?
Yes, sir. She has vacated the property. She has 2 pit bulls, and one of the pit bulls attacked her little brother. And she was told to take care of the dogs, and she went to attack her grandmother, but she attacked her mother instead. So she's been, she's out of the house, but her husband keeps coming back.
Gotcha.
Every week trying to convince grandma and mom and me to let her come back.
All right. There was no written lease, is that correct?
Yes, sir. There's no written lease.
I'll grant a judgment for possession by default to the plaintiff. The writ, if necessary, to issue in 10 days by March 2nd. All right. So you have to fill out a judgment form. You have to fill out a judgment form you can get from the front counter.
Yes, sir.
Okay. And does she still have property there?
Yes, she does, sir.
Okay. So you'll fill out that form, and in 10 days, you'll have another form that you'll have to fill out, which is called the order of eviction. And then you can remove all of her property from the premises.
Yes, sir.
Okay?
Okay, thank you.
Thank you. I don't know that I'm gonna be able to do that. Court recalls HP foreclosures versus all occupants.
Paul Spaniolo, Your Honor, on behalf of the plaintiff.
Mary Cheatham.
Counsel, how are you? I don't know how I get to the point of you saying when I'm looking at this, that this is not a lease. Parties have all signed this. Right?
Correct, Judge. As what was sent to me, I reviewed it in anticipation of us going back on the record. It does appear that it's signed. Other than the consideration provided by Ms. Cheatham, before you as well.
The problem I've got here is that I don't think, quite frankly, that, well, I'll just say it this way, that defendant has a valid lease. And I would submit to you that the beginning of this case, because of that, this court doesn't have jurisdiction to hear this case. I've lost subject, I won't have subject matter jurisdiction under the theory on which this case has been filed. Because you filed it because of the expiration of the redemption period, but at some point, a new lease entered in or new interest in property entered in, which I can see. So I don't think, there may be other reasons or a basis upon which this case could then proceed, but I can't proceed as is. I don't think the court has subject matter jurisdiction. When I don't have subject matter jurisdiction over the case, then the only thing I can do is dismiss it.
I anticipated that, Judge Simpson, and I appreciate that. Would you just be inclined to dismiss it without prejudice, and we'll send out the appropriate notices today and get the ball rolling on an appropriate matter before you.
All right, very good. So, that dismissal is without prejudice.
And respectfully, thank you for entertaining my argument. I appreciate it.
Not a problem, sir. All
Take
right,
care,
thank
Your Honor.
you.
You and your staff have a great weekend.
You do the same. You also, Ms. Cheatham.
Thank you, Your Honor. You have a good day.
Court recalls the case of Arbor Woods versus Roy Williams and Terry Williams.
Rachel
Terry
Dornish,
Williams.
plaintiff.
All right, both of you are here. What are we doing on this?
Your Honor, we did have an opportunity to speak, and I believe we've reached terms for a proposed consent judgment. The total due inclusive of costs is $978.30. That balance in March and the March charges we paid as follows: $500 plus March rent on or before March 3rd, and then the remaining balance on or before March 10th. I did advise Ms. Williams of her rights under MCR 4.201J, and I believe she's given me permission to sign on her behalf. We'd ask for a default judgment with respect to Roy Williams with the same terms.
Ms. Williams, is all of that correct? All
Yes,
right.
I
Do
am.
you have any questions regarding any of the terms of the judgment?
No.
Well, that didn't sound too sure. Do you have any questions?
No, it's unfortunately I just couldn't find my receipt, so it is what it is.
Okay. All right. Judgment to the plaintiff. That is by consent in the amount requested with the terms with the writ to issue as indicated in the judgment. All right. Thank you.
Thank
Thank
you,
you
Your
guys.
Honor.
Have a great weekend.
You as well,
All
Ms.
right,
Williams.
same.
And that's it for me, Judge. Have a great weekend.
Okay, you too.
Thank you.
Evergreen Apartments versus Kevin Sherman.
James, thank you for the plaintiff, Your Honor. Good afternoon.
Mr. Sherman's not checking.
He is not checked in. Get that all right. All right, Mr. Fink. Good afternoon. Would you like to take a default?
Yes, sir.
Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, nothing but the truth, so help you God?
I do. Your Honor, this is an action for non-payment of rent. This defendant, Kevin Sherman, is in arrears $1,289.52 in rent. The taxable costs are $172. We request a default judgment in the amount of $1,461.52 with a writ to issue after the statutory period. This is a possession-only judgment, Your Honor.
Judgment to the plaintiff. That is by default for possession. Redemption amount is in the amount requested with the writ to issue in 10 days.
Thank you.
And you know what I think? I think there's a sticker for this file went the same place as my staff. Because there is none.
You mean right here, Your Honor?
Just saying. All right. Court calls the case of Gulf Site Lake 1 and 2 versus BK. Is it the area?
James Fink for the plaintiff.
How you doing?
I'm doing well. Your name?
Bakay Diarra.
All right. And what are we doing?
Well, he owes $2,941.17. He applied at DHS today, but not within, well, it's today 5 days.
He's past it. Well, hold on a second. Did you pay them $1,000 today?
No, I didn't get to pay the $1,000. I'm supposed to get paid today for my job, so I was going to combine that and maybe get that in by the end of the day or tomorrow.
Okay.
Yeah, but I did call Hawk, like how you told me, and they sent me to the ozone, and they sent me a list of numbers to contact, and I applied through DHS to get the assistance, and now it's just pending.
Did Hawk give you an appointment?
No, I didn't. I don't know.
When did you call them?
This morning.
Why'd you wait so long? I mean,
because I've been trying to catch up on certain bills, and I haven't even been at home like that. So yeah, I've just been trying to catch up on a lot of different things.
Your Honor, we're 5 weeks from the issuance of the summons.
I know. Sir, I'm gonna issue a judgment finding no tribal issue after a hearing for the total amount of 2941.17. And the writ would issue normally on the 2nd. I will have it issued that Friday, the 6th. So I'll give you a little bit of extra time, but you've got to get it together. This doesn't include what you're gonna.
Yeah, I'm just super behind, especially having to pay a car out of the impound, and
No,
it's
I
been
get
a
it.
lot of stuff.
I get it, but it's
Yeah.
gonna get even worse if you don't have a roof over your head.
That's totally true.
All right. Thank you.
I understand. Thank you.
And Your Honor, I'll just say, we looked at the ledger together. Up until this case, he'd been there 18 months and had never had a case filed on him.
On him.
Which is, as the court knows, not something that everybody's able to achieve.
Right.
I hope you make it.
Yeah, thank you.
All right.
Appreciate it.
Thank you.
All right, you enjoy your day.
Court does call the case of Gulf Side Lake 3 versus Latanya Powell.
James Sink for the plaintiff.
Oh, there she is. Hello.
Hello,
What's your name?
Latanya P. Powell.
All right. Where are we on this case? This is your motion.
I'm looking to see if this was a motion or a no writ without a hearing case.
I think it's a motion. I'm sure it's a motion.
I don't know that I have a motion, but she paid $538 after entry of the judgment. She's paid nothing since.
All right, what do you want to tell me? She had indicated her mother passed away. She was taking care of her mom, and then well, why don't you tell me?
Yeah, my life just pretty much fell apart from there. I'm just started as well. I just got a job working for the post office, but I'm in training right now, so I just wanted to let you know that I was sort of working like cleaning houses, but that's not enough to pay my bills, but this job will be.
So what's her balance at this point? Because February
382109, 382109.
Have you gone to apply for assistance at all?
I asked Hawk and they said they could potentially help me if I at least pay like 800. But I feel like, they mentioned that to me before in the past and I brought it down like they told me and they did not help me. So
When was that though?
that was like last year.
Okay. So, and I mean, some of that may have been where they told you that they didn't, and then all of a sudden their funding went away. So it's not that they wouldn't do it, it's just they didn't have the funds there. When do you get paid from this job now? I mean,
With me being in training, I couldn't even tell you. Like, so yeah.
Can you move out this weekend?
If I was to do that, I was thinking next week, maybe. Oh, can I also just be transparent with you? I know my
Absolutely.
bill is looking kind of crazy and everything that I got going on. I'm also a little nervous to like accept time as well because, you know, let's say you give me a certain amount of time and I'm still not caught up. I just would prefer to avoid eviction. Like if I have to move out, I'll gladly do that. I could be out next week. But I just really need to avoid the eviction if possible.
if you're out next week, where would you go?
That's another story. That I don't know, but that can be figured out. What I can't figure out is having eviction on my record for 7 years.
But you don't, right as we sit here now, you don't have a plan to how you're gonna be able to do that.
With my mom passing, my life fell apart. I have no idea that she was really all I had. So
And you just haven't gotten in touch at all with Hawk.
the call that I had with them, that was it. They was like, maybe if you can at least pay 800 and
When
you
was
know,
that?
like that was like last week. I had talked to the landlord and you know that she had mentioned that to try again because I tried with Hawk before. She said try again. So that's what I
Did
did.
you try again or?
I had called, yeah, I called them.
Oh, that was the try again.
Yeah, that was, yeah.
All right.
Is Miss Amy online?
She is. And so here's what I'm gonna do, ma'am. You gotta have a plan in place. Right now, you don't. What worries me is you're not sure what you're doing next,
I have, no,
right?
correct.
So here's what I'm gonna do. I'm gonna adjourn it. I'm gonna give you one more week to try to see what we can get through. So the 27th, 2026 at
2 p.m.
2 p.m. That's an in-person hearing. But what I want you to do right now, I want you to go down to the clerk's office. Can you let them know that you're gonna go into one of our rooms, get on a computer there. They'll sign you into my meeting here. And then I'm gonna put you into a breakout room with Amy, the court liaison officer, and see what resources and other things are out there for you.
Okay.
Okay?
Yep.
Do you have proof that you're employed by the post office?
Yes, I mean, I have my badge, that works.
Oh, okay. So, well, okay. I'm just saying they may, one of the things is gonna be, are you going to be able to sustain, if you stay there, are you gonna be able to sustain living there? And
As far as like, for example, like if let's say I'm working towards knocking down my balance. For me, you know, when I'm in like actually really start the you know, after my training days are over, I will be in the post office. I know from there I can be back ahead, but
no, I got you. I understand what you're saying.
I just don't know as far as the plan of how to get caught up.
Right. I know. That's why we're gonna try to figure that out. Okay? So go down there. They'll be waiting for you. They'll put you on a computer. We'll put you into a breakout room with Amy.
Okay.
And then we'll see you next week at 2.
Okay, thank you so much.
You're welcome. Hamilton Crossing 2 versus Veronica Whitsett.
James Fink for the plaintiff.
Hello, Miss Whitsett. How are you? I think I'm doing okay. We'll see. All right. You filed a motion. So that explains your good cause, but then
That motion either.
right, yeah, we have an issue up front about mailing these out, getting them out.
Well, until Miss Pugh Powell gets on the job, the post office won't get it there on time anyway.
Right. Basically, she's indicating she was at work. She works with people who are ill. She didn't have anybody to relieve her with the client that she was with. All right. So how much does she owe at this point?
2375. She owes 1745 on the judgment. She posted, I think, 660
today,
today.
which brought it up to 2 months rent of 1160. So that would be, I think, 12 something. So my dilemma was I was basically living beyond my means and my finances got stretched. They cut our overtime at work. I don't know what's going on there. But they're basically overworking us, but not wanting to give us the overtime. And it put me in a bind. So now, like everything is behind. I called Hawk and they told me that I made too much money, but I have my son living with me, but they said they had to talk to him and he's in Philadelphia with his father. So they told me without him, I couldn't even make an appointment. So
That's an adult son.
The adult son, he's 25. And so when I went to my doctor's office, like I'm feeling stressed at this point. So the liaison at my doctor's office is trying to help me. But again, that's all I got as of right now. And like everything is super behind. And so I wouldn't be able to rectify it and pay it until the 7th, the balance. And that should
until the 7th
of March. And that would include March's rent. So I would be caught up totally on the 7th of March. And my rent isn't due until the 5th. So basically, if they could extend me with what I have in escrow and what I could pay on the 7th, it'll catch me completely up.
So is that the next time that you have a paycheck? Is this the 6th or 7th?
Tomorrow I get paid, but I've been off work. I had got COVID, so I was off work. So my check tomorrow isn't going to be that much, and I still have to get to work. And I have bills that come out of my check. My car note and everything comes automatically debited. So once they take that in my insurance, I'm not going to have it tomorrow or Monday. Whenever they pay us, they've been sporadically paying us. Sometimes I get paid on Saturday and sometimes I get paid on.
But you can say that you're going to tell me that you can pay up everything
by the 7th of March.
Let's make sure we're all talking about the same number, Your Honor.
Okay, go ahead.
So that'll be about 3,000. And how much do you have in escrow?
$660.
How would it be?
Hang on.
660.
That's all you have? You don't have anything else?
Well, hold on a second. Did you make 2 payments to escrow?
I made one today and
That's why. Okay. I was looking at that receipt and not looking at the register of actions. So I actually have 1160 in escrow. Is that right?
Yes.
Okay.
So she'll owe 2, a little less than 2 in March.
How?
Well, because March rent gets added.
To the 1735, right?
Well, right now you owe 2375.
That's with March's rent, sweetie.
No,
It's not?
No, that's February's rent.
Your judgment was in January.
I'm confused. I'm confused now.
Okay, your judgment, when it was taken. It was taken on January 30th. So it was taken right at the end of January.
Right.
So since that time, your February rent is clicked in.
Which made it 17. I thought 7.
How much is your monthly?
My rent is 580.
The judgment was 1745.
Correct.
And I had made them a payment. I
Five,
really only owed
580 plus a late fee has been added for February, so that's 630. So that took it to 2375. And add another 580 on March 1st. Late fee won't kick in until the 6th, so that'll be 29.55
is what I get. And so at 29.55, then if I count 1160, can you give me that? 29.55 minus 1160. 17.95 or thereabouts.
Look, I guess I got to work on it. I don't have a choice. I don't have a choice. I'm way total off. I'm gonna have to get my ledger from them because it's not. Adding up to me.
So you're what I was going to do is this. I was going to release all of the escrow to the plaintiff. I was going to sign the order of eviction, but indicate that it cannot be executed till, do you get paid that Saturday?
Yes.
Okay. So that it can't be executed until March 9th.
Okay.
Oh, so I'm signing the writ though. So if it's not paid, that she's got to pay March. Part of this also is that she's got to pay March. She's got to have a zero balance. You got me?
Yes.
And I'm going to extend your time, but I'm not going to recall the writ. I'm not staying it. It's going to be out there, but understand if it's not paid on the 9th, they can show right up.
Gotcha.
They can go all the way up with the preparation of doing it.
Gotcha.
You understand me?
Yes.
Is that Mr. Moore?
Yes, it is.
I want to make sure that he understands not to.
Yes, we will make sure.
Thank you.
You said 1735? That's what.
1785, but check with the office because by the 9th, it'll be another 50.
Okay.
You can have that.
Oh, thank you. All righty.
You know what you need to do? Go find some money.
Yeah.
Okay.
Definitely, for sure.
Thank you, Your Honor.
Thank you. Well, man, this writ needs to be prepped. And then just put on there. Yeah, you can put it on there. Not to execute it for the night, but also send an email and more. All right, thank you.
Thank you.
Gulfside Lakes 3 versus Harley Argo. That matter is dismissed on plaintiff's motion without prejudice. Thank you. Who is? Miss Argo?
Yeah, I'm here.
Okay. They dismissed your case.
I
Is
know.
that all?
Yeah, I just wanted to hear you say it again.
Okay. All right.
All right. Thank you so much, Judge. You have a good weekend.
You do the same.
Thank you. Bye-bye.
Real Properties versus Cozine Welch.
Lacey for Bill Properties, Your Honor.
They're not here. You want to take a default?
I definitely do.
Raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, and nothing but the truth, so help you God?
I do.
Go ahead.
Thank you, Your Honor. At this time, we would be requesting a default judgment for possession only where the outstanding rent to retain is $3,265, court cost of $175, total outstanding balance is $3,440. We're asking for a pay or vacate date of March 2nd, 2026.
Judgment to the plaintiff. That's by default for possession. Redemption of the amount requested with the petition, 10 days.
Thank you, Your Honor.
Woodview Commons versus Whitney Albright.
April Lake Woodview Commons, Your Honor.
Hello, what's your name?
Whitney Albright.
All right. What are we doing?
Thank you, Your Honor. I did get a chance to speak to Ms. Albright, and she's indicated to me that she'll be able to have everything paid before the end of the month. So we entered into a consent judgment, giving her until March 2nd to have the balance paid in full, which is currently $8,311.42 in past due rent, $175 in court costs, a total of $8,486.42. I did advise her of her rights under MCR 4.201 subsection J.
I was just gonna wait for Lacey to finish before I start talking. Because see, if I start
Said you
talking,
were gonna do that. You were gonna.
I was gonna do what?
Nothing.
Was she talking? Was she talking about me?
No, never.
No, was she? See, this is what I'm talking about. It's how people get in trouble. Ma'am, you're gonna be able to get that all paid by then?
I am, yeah. Yep. I actually have taxes. They're coming back in and I showed her too the proof of it. It was all accepted. And luckily I paid a lot in, so I'm getting a decent amount back. So we're gonna be all set.
I wish that worked that way for me. I just keep.
Right?
I don't know.
Actually, I have to thank my tax person last year because I paid so much in. She's like, we're gonna take a bunch out this time and set you up. So
That way. Okay, gotcha.
Yeah.
All right. Then I will enter. Give me a judgment. Yes. All right. So you had no questions regarding any of this. Is that correct?
Correct.
All right. Well, under judgment by consent, you've been apprised of your 3-day rescission rights. All right. Very good.
Thank you.
Thank
Your
you.
Honor.
Have a good weekend. Thank you, Miss Lacey, for not saying anything real bad about me.